Morning. We'll roll call in just a sec here. Stand by. Okay. Good morning and welcome to the final installment of this Council's Executive Committee. For August 23rd, I'll call us to order. Recognize that we're having today's meeting on Treaty 6 territory, the traditional territory of the Cree, the Dene, the Saulteaux, the Nakota Sioux, and the Blackfoot peoples, as well as one of the great homelands of the Métis Nation. I will roll call to establish attendance from members of the committee first, and then check to see if we have any interlopers. Councillor McKean.
Good morning, Mr. Mayor.
I can see you live on deck. Councillor Cartmel.
Good morning.
Live and on deck as well. Councillor Hamilton.
Was that me? Sorry?
Yes. Good morning.
Yes. Good morning.
And Councillor Walters.
Good morning.
Morning. And have we got, I see Councillor Banga.
Good morning.
Morning. Any other members of council joining us this morning?
Good morning.
Good morning, Mr. Mayor.
Councillor Essinger and Councillor Knack. Morning. Anyone else? Okay, not seeing any. Let's deal with the agenda. Can I get a motion to approve the agenda with some additions and replacement pages? Councillor McKean?
Yeah, Mr. Mayor, I'd be happy to move the agenda with the additions of 6.3, approval of expropriation Yellowhead Trail conversion, 9.4, approval of expropriation type damages and approval to pay reasonable legal and expert costs, 9.5, transit pilot project agreements, replacement attachment on 6.1 GEF seniors housing, Holyrood. Yeah. I'll stop there.
Thank you. Any questions on the agenda as presented? Any other changes? Okay, not seeing any. Please vote on the adoption of the agenda.
We have 5 votes, Mr. Mayor.
Display the vote, please. Carried unanimously. The minutes from August 9th.
I'm happy to move the minutes from the August 9th meeting.
Thank you, Councillor Cartmel. Any questions, concerns, errors, or omissions around the minutes? Not seeing any. Please vote.
And we have 5 votes, Mr. Mayor.
Display the vote. Carried unanimously. Protocol items. I don't think we have any. Let's select items for debate then. Councillor McKean?
Mr. Mayor, I see that we have a request to speak on 6.3, so I will select that for committee. And I also have a couple of questions on 9.1.
Okay. Any other selections? Going once.
Mr. Mayor, I wonder if we should actually select 9.2 in case we need it, just because it seems to be a companion to 6.3.
Okay. 9.2 is selected by Councillor Cartmell.
I can move all other items, Mr. Mayor.
Okay, thank you, Councillor Walters. Please vote on those items not selected for debate, which is most of them.
And we have 5 votes, Mr. Mayor.
Display the vote. Carried. You want to read back what we've taken care of, please?
Certainly, thank you, Mr. Mayor. This morning, Executive Committee has passed the recommendations in the following reports without debate. Item 5.1, Alternative Surplus School Site, Henderson Estates Park, with a revised due date of fourth quarter 2021. Item 5.2, Engagement with Homeowners Associations as City Building Partners, with a revised due date of fourth quarter 2021. Item 6.1, GEF Seniors Housing Holyrood Land Lease. Item 6.2, 2021 Affordable Housing Site Sale of Land Below Market Value and Grant Funding. Item 6.4, Use of Neighborhood Renewal Funds, Exception to Policy C595A. Item 6.5, Railway Warning System Sole Source Agreement. Item 9.3, Land Acquisition. Item 9.4, Approval of Expropriation Type Damages and Approval to Pay Reasonable Legal and Expert Costs. And item 9.5, Transit Pilot Project Agreements.
Excellent. Requests to speak, we've got a few on 6.3.
Mr. Mayor, I'd be happy to move that committee hear from the following speakers in a panel. On item 6.3, Alim Somji, Yellowhead Motorhen, Ramada Edmonton Yellowhead. In person, it says. Paul Barrett, in person. Jessica McDonald, remote. Shauna Finley, remote. And Earl Strawshine. I don't know whether Earl is in-house or remote.
It says remote on my sheet here, so. But we'd hear from all those folks in a panel. Any other requests to speak come in since this was put before us?
Not that I'm aware of.
All right, then let's vote on this proposed panel.
And we have 5 votes, Mr. Mayor.
Display the vote, please. Carried. There are no requests for time specific. Are there any councillor inquiries? Not seeing any, then let's turn to item 6.3 in a moment, but the way this will work is we will hear a presentation from administration, and in the particular matter of 6.3, we're sitting in our capacity as the representatives of the Expropriation Authority for purposes of the hearing today. Ultimately, the decision is before council next week, but the hearing is today. There'll be an opportunity to hear presentation from administration, followed by presentation from members of the public who and interested parties who've registered to speak. We'll hear from each of those folks in succession, one at a time, until we've heard all 5, and then we'll ask questions of the panel, and then turn our attention back to city administration for further questions. And just a request that if you're dialing in from remote to not use the chat function in Google Meet, because it can create issues of decorum or fairness while others are speaking. And also suggestion to keep a timer of some kind with you so that you can judge the passage of the 5 minutes for yourself. The clerks will keep the official timer in the room here. And you'll see the stoplights on the podiums here that will alert members of the public as to the passage of the 5 minutes. There's 4 minutes on the green, 1 minute on the yellow, and then the flashing red would indicate the end of the 5 minutes. But please stay at the podium or stay at your mic as there may be some questions once we've heard from everyone. The one other thing I would say is if you're having any technical difficulties whatsoever, please reach out using the contact information provided in your registration or via city.clerk@edmonton.ca, and we'll do our best to make sure everyone can participate fully in the conversation. So I will now, having outlined that process, turn it over to administration to provide any introductory remarks on item 6.3. Which is the approval of expropriation Yellowhead Trail Freeway conversion, consideration of inquiry officer's report for 14950 Yellowhead Trail.
Good morning. I'm speaking to item 6.3. In this report, administration is seeking approval from City Council as the approving authority under the Expropriation Act to expropriate a portion of land located at 14950 Yellowhead Trail. The land is required to support construction of the Yellowhead Trail Freeway Conversion Program and to preserve the timelines required to deliver the project. Back in November 2020, Council approved the commencement of formal expropriation proceedings in relation to this property, along with several other properties. Administration is seeking to expropriate a small portion of a larger parcel. The area required is approximately 0.124 acres, which is 1.8% of the total land area of 6.78 acres. Formal expropriation steps were initiated in April 2021 when the notice of intention to expropriate was registered on the title of the property and served on the property owner and registered interest holders. Upon service of the notice, the registered owner and 3 tenants objected to the partial expropriation. The basis of the objections was that it would be unfair for the city to only expropriate part of the land rather than the full parcel because of the impact of the overall project on the businesses on the site. As a result, as part of the statutory process, an inquiry hearing was held in June 2021 to inquire into whether the partial taking is fair, sound, and reasonably necessary in the achievement of the objectives of the expropriating authority. The inquiry officer issued a written report, which is attached as attachment 2 to the report before executive committee. In the report, the inquiry officer made 2 recommendations. 1, that City Council approve the partial taking as being in the public interest and to preserve project timelines and avoid delay. And 2, that City Council commence a companion or subsequent process to acquire or expropriate the full property. The inquiry report is non-binding on City Council. That means that City Council is not bound by the recommendations of the inquiry officer. However, under the Expropriation Act, City Council, as the approving authority, must consider the inquiry report before it makes a decision on whether or not to approve the expropriation. The decision that Council must make is set out in Section 18 sub 1 of the Expropriation Act, which states, the approving authority shall consider the report of the inquiry officer and shall approve or disapprove the proposed expropriation or approve the proposed expropriation with any modifications that the approving authority considers proper, but no approval shall be modified so as to affect land of a person who was not a party to the inquiry. Council must give written reasons for its decision, which will be served in the parties to the inquiry. In this report, administration recommends that Council approve the partial taking, as the land is an undisputed requirement for the project, and the partial taking was also recommended by the inquiry officer. None of the parties to the inquiry disputed that the city needs this small piece of land for the project. The rationale for the partial taking is set out in attachment 4 to this report. Administration also recommends that Council make no direction at this time to acquire or expropriate the full property, given that there is not currently enough information before administration to justify taking the whole property. Administration is currently continuing to work with its retained outside experts and the landowner to see if there's a business case for taking the entire parcel. There is also an ongoing separate legal proceeding. The landowner has filed an application under Section 15 of the Municipal Government Act for the Land and Property Rights Tribunal to determine whether or not the city must expropriate the whole property, which is scheduled to be heard in November 2021. If the city and landowner cannot come to an agreement, the issue will be decided by the tribunal. Joining me today are Gordon Buck of Legal Services, Jason Malista of Infrastructure Services, Chris Lima of Infrastructure Services, and Bart Draki of Financial and Corporate Services. Upon hearing from speakers, we would be happy to answer any questions that you might have.
Thank you. Mr. Somji, I see you're in the first position there, and Mr. Barrett, you're in the second. So we'll hear from each of you, followed by Ms. McDonald, Ms. Finlay, and Mr. Stroshine. So again, you've each got 5 minutes. Mr. Somji, the floor is yours.
Thank you, Mayor Iveson. If it's all right, I'll go first, and then Mr. Somji will follow.
Oh, sure. So Mr. Barrett first, followed by Mr. Somji. No problem. Go ahead.
My name is Paul Barrett with Prowse Chown LLP, and I'm counsel for Yellowhead Motor Inn Limited and Petro Jaffer 116 Limited. Yellowhead Motor Inn owns the land and it operates the Ramada Hotel on the site, and Petro Jaffer 116 Limited operates the Husky gas station on the site. Mr. Alim Somji is the principal of both of those companies. The advice of the inquiry officer in her report, as stated by your administration, omitted one word. Her second recommendation was to forthwith commence as a subsequent or companion process for the voluntary acquisition or expropriation of the entire YMI property. And what we're asking you to do today is to commence the expropriation of the full property today, whereas your administration is asking you not to make a decision on that today. The problem is that the partial taking of the lands causes extensive collateral damage to the remaining lands and to the businesses that operate on those lands. The city has to compensate the owner for those damages in either event, if it's a partial taking or if it is a full taking. But really, if it's a full taking, there's no compensation because the city just takes the whole land and there's no more problem. And so that's a solution, and that's why the inquiry officer suggested it, take the whole land. The inquiry report shows unequivocally that the partial taking is more expensive for the city, the full taking less expensive. Where the partial taking causes suffering, the full taking diminishes that suffering with no cost to the public good. The inquiry was an 8-day hearing. 6 of those were spent on evidence. There were 7 experts called: transportation engineers, forensic accountants, land appraisers. In legal fees, this inquiry probably already cost the city well in excess of $500,000. There's another hearing set for November, yes, where the Land and Property Rights Tribunal is requested to compel the taking of the entire parcel. But with the inquiry officer's recommendation, the city should not make the owners fight and litigate to compel this solution. The owners will cooperate in the solution. There's a mechanism called a Section 30 agreement. They'll agree to the expropriation of the entire property. Councillors, we're here with faith that you'll be discerning in choosing which advice you follow today. Council initially approved the commencement of this partial expropriation on the recommendation of its administration, and at the time you had no reason to do otherwise. The inquiry process under the Expropriation Act is a tool as much for you as it is for your citizens. Whereas you might have made the initial decision with much deference to your administration, the inquiry officer held an extensive hearing on this issue. The advice to proceed with a partial taking that you had initially followed was rigorously tested, and it was found to be unsound and unfair. However, in attachment 4 of your package today, administration is recommending that you not commence expropriation of the entire parcel today. What are the reasons it gives you? Well, frankly, those reasons aren't clear, at least from a reading of attachment 4. There's some suggestion that more information is required. But there was a full hearing on the issue, and I've talked about how extensive that hearing was. We hope that our aggregate 10 minutes, maybe 30, with the other business owners who are here can impress on you the gravity of the expense and time that went into the inquiry hearing already. It's recommended a solution, and we ask that you carefully read the inquiry report itself. Paragraph 20 of administration's report refers to the risk that a second expropriation could give rise to another inquiry. Is the suggestion that the owners would object to the solution that they've asked for? Because they won't. And if we enter into a Section 30 agreement, there's not going to be another inquiry. The possibility of the city's compulsion by law under the Municipal Government Act to take the entire parcel is a reason to do it willingly, not a reason not to make a decision, not a reason to wait and see if the administration prevails in a second hearing over whether the partial taking is unfair, particularly when a first hearing has already held its unsound and unfair. Speaking of the city's lack of justification for a partial taking, Inquiry Officer Roberts said,
Sorry, Mr. Barrett, if you could sum up. We're at the close of the 5 minutes.
I'll sum up, 20 more seconds, please. Inquiry Officer Roberts said, to the extent it invites an inference that the only reason is to make landowners fight for every remedy to which they may be entitled under the Act or other legislation if applicable, I find it is also unsound. Deferring your decision today keeps us on track to fight in November. We're asking you to make this decision, set the matter on track to a resolution. Please ask Council to commence the full expropriation next week. It's the more practical, the more economic, and the more honorable course of action. Thank you. I now pass the mic to Mr. Somji.
Thank you, Mr. Barrett. Mr. Somji?
Thank you very much. Ladies and gentlemen, I will try and be brief. I wanted to appear today to really impress upon two things. Number one, the approach that we've taken over the last 9-10 years as this project has first been introduced and then time has followed on. We've tried to be as engaged and as diligent to following the city's process as we could be. We don't have any previous experience in expropriation. I don't foresee any of our other properties having a freeway built through them, thankfully. So, we were really left with the approach that was provided and the avenues that were provided by administration in the city. We put faith in that, and to be honest, I continue to put faith in that. But we want to make it very clear that at all points in time, this was both the desired outcome and, to be honest, in our minds, the only outcome. The property will not survive when the accesses are removed, regardless of how much land is taken. And the basis of our objection to the expropriation was that. The property is cross-collateralized with a number of other ones. This doesn't just involve one individual or one person. This is all of my staff, all of my tenant staff, staff of the other businesses that are involved in this financing. The failure of one will cause the failure of the others, and I don't believe it's fair or necessary for that to happen. The second thing I want to impress upon is that to the extent that we are able to, we've been able and willing to accommodate administration, to accommodate contractors, anybody that had needed to work on this project in doing their work. We've admitted utility construction to begin without any settlement on expropriation to this point. And we will continue to. I want to make clear that we do not intend to stop this freeway conversion from happening. I know that's not possible, and I know that's not in the public good to do so, but we do want to be treated fairly. And we do want to be treated in a manner that will allow us to make decisions for our staff and for ourselves in a prompt manner that would allow us to move forward and not punish us unduly and punish our other investments by continuing to drag this process out. I'm very well aware that we have other remedies that that administration had recommended. We do intend to continue to follow those, but our main goal is to come to a solution. I don't want to continue to sit through hearings. I don't do this for a living. It's not our intent to be obstructive. We want a solution, and we want a fair solution, and the sooner the better. So I would respectfully hope and ask that you take into account the inquiry officer's recommendations, the report, and really understand that the business itself, through all of the evidence that we provided, through the extensive evidence that the city provided with their experts, the inquiry officer objectively concluded that the proposal was damaging to our business and that the correct course of action was to purchase the property. And I sincerely hope that that is the solution we work towards. And again, as I stated before, we are happy and willing to do whatever it takes to work with administration, to work with yourselves to come to a conclusion. Thank you.
Thank you, Mr. Somji. Ms. McDonald, are you on the line?
Yes, are you guys able to hear me okay?
Yes, proceed.
Awesome. Hi, my name is Jessica McDonald. I'm the manager of Husky's real estate team in the retail department, which has responsibility for, among other things, the selection and siting of gas stations. I've been with the company for the past 7 or 8 years. In my role, I oversee strategic planning, network planning, and asset acquisition, amongst other things. This includes oversight over the investments that we choose to input into the retail business, including looking at new properties, validating the economic viability of potential new sites, and assessing whether poor performing sites should be closed. I'm here because Husky leases and operates a gas station site on the Ramada site between 151st Street and 149th Street, just off the Yellowhead. It is a gas bar, convenience store, and car wash. It is currently accessed easily off of the Yellowhead, and customers can exit Yellowhead in close proximity to the gas station. So customers are able to enter, fill up, and then rejoin the Yellowhead at 151st Street, traveling westbound. The access to the Ramada site is relatively straightforward today, which is part of what makes this site a compelling asset and a high-performing site. In 2008, before signing its long-term lease, we made significant investment, around $3.4 million, into the site, based in large part on the access and locational attributes of the site. We executed a 20-year lease with 2 5-year terms to renew for this property. The city is seeking to expropriate a small portion of land off the southern portion of the Ramada parcel, which cuts into our lease area and forecloses the continued operation of the car wash. The car wash business generates about 20 to 30% of the revenue from the station overall. Further, the city has decided to close both access points to the gas station, which will remove convenient access and restrict traffic. The inquiry officer reviewed the proposed expropriation and our evidence and arguments, along with others. We argued that it was far more fair to the owners, both tenants and the fee simple landowner, if the city expropriated the entire Ramada site, because with the changes, the business will no longer be able to survive once the city's changes to the Yellowhead take place. In fact, the city did plan on taking the entire parcel until around 2017, based on its consultation and engagement with stakeholders. As noted by the inquiry officer, no good reason was given for this change by the city. From our perspective, a taking of the entire site made sense and reflected the reality that the gas station, among the other businesses, will no longer be able to survive after the changes are made. An expropriation of the entire site for Husky and other tenants actually mitigated the negative impacts of the project fairly. Reducing the land size of the taking actually increases the impacts to Husky and others and creates uncertainty and risk. From our perspective as a business that operates in jurisdictions across Canada, we understand that municipalities have to make changes to update infrastructure, but we expect to be treated fairly and in an upfront manner when our rights are going to be compromised. In the current case, the city did not actively engage Husky. It did not reach out when its plans changed from an expropriation of the whole site to only a partial acquisition. Questioning during the inquiry established that the city did not even ask the landlord whether it could have permission to communicate with Husky. So in contrast to other times where the city may not get permission from the landlord, they did not even ask in this case. The city has made no effort to negotiate with Husky for the acquisition of its lease. Husky will be making a claim for compensation in this expropriation, and whether the city takes the entire leased area or not, Husky's gas station will have to close. An expropriation of the entire leased area provides certainty and a clear basis for resolving damages and compensation issues with the city. Husky supports the findings and recommendations of the inquiry officer to City Council as they relate to the proposed taking, which is to allow the proposed taking to proceed and to commence a companion expropriation process for the entire site. Thank you very much.
Thank you. Next, we'll hear from Shauna Finlay.
Thank you very much. I'm not going to repeat many of the statements that Mr. Barrett made, which we adopt and agree with. I want to draw Council's attention to a number of the findings and statements by the inquiry to frame my remarks and to, I guess, highlight some of the findings of the inquiry officer. In the inquiry officer report at page 21 and going over to 22, you'll find that there's a chart which summarizes the difference in impact for the expropriated parties between a partial taking and a full taking. And it reflects that, in fact, the impact is less if there is a full taking. The other thing I wanted to point you to, which I think is very important for you to consider, is the chronology that was attached as Appendix A at page 31 of the inquiry officer's report. And the reason that I think this is so important is the following. The city did engage in an extensive consultation process in connection with the Yellowhead Freeway project. And it engaged this process so that it could understand intimately the impacts that that project would have on the parties that will be affected. The result of that process was a June 2017 concept planning report that did contemplate taking the entire property. The entire property was never needed for the project, but that plan to take the whole property reflected the gravity of the impacts that would result to that property. Subsequently, there was a change to that plan that was communicated to the parties in 2010. And I guess one of the things that the inquiry officer talked about and that I would impress upon you here is when you engage in such an extensive consultation process, part of the reason for doing that is to engage your citizenry and actually have their comments reflected in the project as it goes forward. Your role today is to make a decision on, in fact, what will be taken and how the project will move forward in respect of that. By making the changes to the proposed expropriation, effectively what the city did was ignore all of that consultation process and make a decision based on a very narrow understanding of what its needs are. But the expropriation process is not intended to only focus on the needs of a municipality. It's intended to balance those needs against the impacts to landowners, and that's what the inquiry process is about. It's about looking at that balance and saying, is it fair? And in this case, it was very clear after hearing extensive evidence that the inquiry officer found that it was not fair, but that unfairness could be mitigated by proceeding with the intended expropriation and commencing forthwith a second expropriation of the entire parcel. The other statement that I wanted to highlight for you, which I think is really important and is critical to your role today, is a quote that is found on page 28 in paragraph 147 of the inquiry officer's decision, where she quotes from a 1967 Ontario Law Reform Commission report, which talks about the role of City Council in making these decisions. And what it says is that an important consideration is the fact that all government activity, whether on a provincial or local level, should aim to retain the confidence of its citizens and their respect for its fairness. Every attempt should be made to cause a minimum of disturbance in the life of the citizen. City administration does not make this decision. This is your decision today. And it's important because it's the democratic process that provides the check and the accountability for that decision. And so I encourage you to read the inquiry officer's report, read her assessment of the evidence, and follow her recommendations. Thank you.
Thank you, Ms. Finley. And lastly, Mr. Strasheim.
Good morning, Mr. Mayor, Executive Committee. We're the restaurant DS Classic that's located inside the Yellowhead Inn. For us, it's really important to follow the inquiry officer's recommendations. We're a small business. We're a small business employer. The current plans would devastate our business because it would not allow access to the hotel and not allow access to our customers, would not allow any advertising. It wouldn't work the way that it's proposed. We were involved with the inquiry officer hearing, and we have no experience in this at all. But we certainly appreciate the recommendation and urge that it be followed. That's really all I have to say. I appreciate your time.
Thank you. Questions for our speakers? Councillor McKean?
Yeah, thanks, Mr. Mayor. And I feel like I want to be really careful in my questioning here. But Mr. Barrett, I think your argument was that taking the whole parcel would actually, I think you would use the term pragmatic, but I think you're also suggesting might be at lower cost to the city and our citizens who are representing in this transaction. So could you unpack that for me, please, so I fully understand your argument?
Yes, I can. Thank you for the question. In the event of a partial taking, the compensation that the owners are entitled to are the market value of what's taken. Then second, they're entitled to what's called injurious affection to the market value of the remaining land. The injurious affection to the market value of the remaining land, in the opinion of the only appraisal evidence that's seen the light of day on this subject so far, I believe is, I don't have the figure exactly in front of me, I believe it's $8 million. The city is also responsible to pay for any damages, business loss damages, and other damages. It's an open category caused by the expropriation. There's a forensic accounting report showing that the loss in revenue caused to the Ramada Hotel is in multiples of millions of dollars. Loss of revenue to the gas station is in multiples of millions of dollars, and it's no longer profitable for the gas station to operate given the partial taking. When you add up these numbers and compare it to the market value of the entire parcel, And again, at this point, the only appraisal evidence that's seen the light of day is that the entire parcel is worth, I believe, $13.8 million. All of the damages exceed the value of the full parcel. Now, if the city takes the full parcel, there will still be damages. There are damages that apply in either event of a partial taking or a full taking. For instance, there are franchise termination fees. So if the partial taking kills the businesses are still going to have to pay their franchise termination fees. If the city takes the full parcel, the businesses are going to pay the franchise termination fees. So there are some damages that are payable in either event, but for the damages that are payable as a result of a partial expropriation, plus the market value compensation due, the evidence before the inquiry officer was that the total damages in a partial taking exceeds the compensation awarded in the event of a full taking, based on the best evidence that's available today. There's a certain amount of foresight that's required, because these events haven't happened yet, it's hypothetical. But if the city takes the full parcel, and if it disagrees that the remaining land is going to be devalued, then it takes the full parcel and it enjoys the value of that parcel, whatever that may be. But the evidence is that it's going to be devalued significantly and that the business losses are going to be gigantic. And as Mr. Somji said, the repercussions go beyond even what's a matter of compensation, because there are other businesses that are cross-collateralized with the businesses on these lands, and there will be ripple effects across the city.
And it is a point that is accepted now, that there's no way to mitigate the business losses and offer access to the site, given the partial expropriation. If that goes ahead, there's no way to, in your opinion, to mitigate that, to allow access.
That's right, and not only in my opinion, but no one has offered us a solution that could potentially mitigate. Most of the losses are caused by the access changes, and according to the city, those are required for the project, such as the closure of the 149th Street Yellowhead intersection. I mean, that's one of the largest impacts.
Right. Okay, thank you very much.
Other questions? I wonder if you might respond to the arguments that are in administration's report to us, that essentially all of these questions, and I understand you've presented a tally that says that, the arbitrage is essentially be easier to do this all in one shot and negotiate it rather than leave it up to the Land Compensation Board to determine what those damages might be. But administration's argument, as I understand it, is there is a separate process for handling that question, absent a full taking, and that notwithstanding that the hearing spent a lot of time on that question, that wasn't necessarily the right venue for answering that question, which you've also put to us here, which is what ought the compensation to be in the event of the partial taking. So I hear you arguing that it would be greater potentially than just taking it holus bolus, but I'd like your response to their argument that there is a time and a place and a venue to answer that question that isn't here and wasn't the hearing that just happened.
Well, first, I have a couple of responses to it. First of all, the inquiry officer herself considered her own jurisdiction and found that she had jurisdiction to consider all of the evidence that she did, and she rendered her opinion. So that's the simple answer, the short answer. The longer answer is that, and she was not determining compensation as a final end. She was considering the compensation payable to determine the fairness, the soundness, and the reasonable necessity of the taking. You need to consider that. If the landowner has to go to the Land Compensation Board to seek their full compensation, they have to suffer the damages first and then claim them back. That's a 5-year, I mean, in a matter this complicated, 5 to 10 year process of suffering damages, and businesses suffering while they go and prove and fight and struggle to get the compensation that they're owed. as opposed to the entire parcel being taken, and there is no suffering. And so even if the compensation paid is the same in either event, and there's philosophical reasons to expect that maybe it ends up being the same in either event of a partial or a full. Why make them suffer? And why have suffering businesses on the land for 5, 10 years? And in the meantime, having these ripple effects and the collateralized companies suffering as well, when it could be solved, but with a full taking right now.
Assuming, well, I guess that full taking hypothetically could go one of two ways. And we've heard Mr. Somji suggest that there's willingness to negotiate that as a Section 30 rather than have it, then go through a more adversarial process. But it's not a foregone conclusion that the parties will easily agree on the value. And then you may have to fall back to the Land Compensation Board anyway, as I think administration's other argument that you may wind up in the same place either way.
Yeah, there are two processes. I mean, just to make sure we're on the same page. If there's a partial taking, then the compensation claim is before the Land and Property Rights Tribunal. If there's a full taking, and if there's a partial taking, there's a separate application before the Land and Property Rights Tribunal to compel a full taking.
Which you may avail yourselves of if push comes to shove.
If we can't make a deal. Yeah. Right. And so if there's a full taking that's not a Section 30 agreement, or if there's a full taking that's not fully resolved, and then the compensation claim for that goes to the Land and Property Rights Tribunal, but there's no prolonged suffering while we wait, and the claim will likely be much smaller for that Land Property Rights Tribunal while we wait for a decision and sort things out. In a partial taking, the businesses are left to, so to speak, die on the vine. They're cut off from their customers. They're struggling to survive while they're pursuing their compensation claim and working out where they're going to go and how they're going to close as gracefully as they can. But it's a messy situation.
So the thrust of your argument is that there is less injurious affection in the full taking, ultimately.
Yeah, in a full taking, there is literally no injurious affection because all the land is taken.
Yeah. And your point about suffering to make the point to demonstrate the scope of the injurious affection versus presuming that would be the case and heading it off at the pass. And that's your argument, and that's the inquiry officer's argument.
Yes.
If I understand correctly. Okay. Other questions for our panelists? Councillor Cartmel, go ahead.
Yes, really just one then, coming from that conversation. That is that, I guess, another way to state the decision in front of us is on a full taking, we're relying on projections, we're relying on inferences, we're relying on predictions in terms of values. Whereas if we were to wait for the process to follow through and understanding and acknowledging your comments about leaving the businesses to suffer, but at the end of that suffering, then the city has an actual factual accounting of the actual factual suffering, and we compensate on that final number. Have I got that correct? We're either acting on projections or we're acting on actuals.
That's right, but there's one more point to kind of fill out that context, because if you don't make a decision today, the Land and Property Rights Tribunal has a hearing in November, and it's going to decide, based on projections, whether or not to compel the full taking.
Okay. Okay, thank you.
Any other questions for our presenters? Not seeing any. Then you can all stay on the line for now. If we need legal advice, which we may. We'll cross that bridge when we get to it, but let's start with questions that are public. Councillor Carmel?
Thank you. So, I guess, speaking conceptually then, we've undertaken expropriations on a number of projects for a number, in order to allow those projects to proceed. And those expropriations in the past have considered partial versus full expropriations, and they've considered matters like, would a partial expropriation leave, essentially render the property either unusable or unusable in its current state, or, those kinds of things. Is that not true?
Yes, Councillor Cartmel, I'm Gord Buck with Legal Services. Yes, that can be a factor in some partial expropriations where, for example, the area being expropriated includes the only access to the property. Then that would obviously have an impact on the future use of the property. There's other cases involving partial expropriations like this one, where we have a partial expropriation of a piece of land, and then there is a separate process to close access to the property by bylaw, which was done in this case, bylaw 19468, if memory serves, where the access closures are not part and parcel of the expropriation. So there is a distinction between those two situations.
When we've closed accesses before, does that generally or typically come with some accounting of or some compensatory payments reflecting those closures?
It all depends, Councillor. There's a mechanism under the Highways Development and Protection Act to allow for compensation to owners who have had access to their property impacted or removed. Typically, it's only available to owners as opposed to tenants. And one of the tests is whether there is reasonable alternate access to the property. And if there isn't, then yes, typically compensation would be looked at.
So are we getting into some fine legal or fine process or fine both points where we're talking about what land we need to build a road versus the effect of changing access to a piece of property? And like, are we essentially concerned that the expropriation process is being used inappropriately for what should be an access closure process?
Councillor, I think it's fair to say that that was certainly our position before the inquiry officer, that these are distinct issues, impact caused by the entire project, and including the impact on access that we heard about earlier, particularly the loss of the 149 Street intersection, that's really what is driving the harm that these impacted businesses foresee, as opposed to the actual taking of the land itself. So that was a distinction that we drew or attempted to draw before the inquiry officer. She didn't agree with us on her findings on jurisdiction. We don't agree with the inquiry officer on her findings, but ultimately, as it's a non-binding decision, we don't really have any opportunity to pursue that any further.
So maybe in more straightforward terms, we want to grab a sliver of land to build a ramp. And the concerns being presented are that removing the overpass, removing the opportunity to impulsively stop at this location, to see the sign and turn a corner. Are we suggesting that those are two separate issues and that they are being conflated here?
That's certainly part of it, Councillor. I think another part is that there is some disagreement in terms of the actual impact on the property. Obviously, the owners have their view, which is that with these changes and the proposed project, that all the businesses on the site will be completely non-viable. They've provided us with expert opinion evidence to that effect, which we are having reviewed and digested and analyzed by our own experts. But at this point, we're not prepared to say that is in fact the case.
There was a suggestion that several years ago, the city was prepared to enter into a full expropriation, and that we changed course. Can you just dig into that briefly?
Very briefly, Councillor, there was a concept plan prepared actually back in 2015, which identified the entire property as a potential land acquisition for the purpose of budgeting for land acquisition. At that point, no detailed design had been done. As that detailed design went through following the concept planning, the land requirements were refined and the project did what they could to minimize the taking required. So that's how that was refined down from flagging it as a potential requirement for budgeting purposes down to the actual detailed design.
Thank you. That's my time.
Other questions? I've got some that probably require advice from the city solicitor. And so I'm going to suggest that unless there are any other questions that can be asked publicly, that in accordance with at least section 27 and perhaps 25, disclosure harmful to economic and other interests of a public body, that we should go in private to ask a few questions. Could I get a motion to that effect? I don't know if you want to cite any other FOIP sections.
Section 24 is also referenced in the recommendation of the report for
Advice from
attachment
officials.
7.
Yep,
But
okay. All right.
Move we go in private to deal with the matter.
24, 25, and 27. Please vote to go in private. And I'm gonna, once we do that, give the clerks a few minutes just to determine what you want to do with the hybrid meeting, and we'll need to excuse our speakers just so we can get some privileged advice. But is the vote coming?
the vote doesn't seem to be coming through, so if you wouldn't mind a roll
Sure.
call vote, Mr. Mayor.
I'll just roll call it. Councillor McKean?
Yes.
Councillor Cartmell?
Yes?
Councillor Hamilton?
Yes.
And Councillor Walters. Councillor Walters? Okay, we seem to be missing Councillor Walters. I am in the affirmative as well, though, so that's at least 4, which is enough. So let's take 5 minutes here just while the clerks get set up, and let's see if we can get Councillor Walters back on the line too. So stand by, and if you gentlemen could excuse us just for a few moments here, we'll let you know when we're back in public. So. Have we got everyone back on the line and doors are open? Folks have been let back in? Okay, so the recommendation before us,
Do you want me to move the recommendation at this point on 6.3, Mr. Mayor?
go ahead, if you wouldn't
I will
mind.
move that recommendation in 6.3.
As presented in the report.
Yes, as presented in the part in 3 points.
Do we need to add anything that the verbal advice given also be kept in private?
Yeah, yes, Mr. Mayor, if we could add a part 4 that just keeps the discussion in private as well.
Okay, so Councillor McKean's motion is the first 3 points that are in the written report as presented, and point 4 is that the discussion of the August 23rd, 2021 Office of City Manager report remain in private pursuant to Section 24, Advice from Officials, 25, Disclosure of harmful to economic and other interests of public body, and 27, Privileged information of the FOIP Act.
Thank you, Mr. Mayor. I'm happy to add that.
Okay, that's your motion. Did you want to speak to it? Okay, maybe I'll just say a few words, which is that we appreciate the presentations made here today, and clearly it's a complex file with several different moving pieces that we've heard presented, multiple tenant interests, access issues, and options, certainly, as outlined by the inquiry officer about different ways this could unfold. But I think clear agreement all around that at minimum, in the first instance, the partial taking is necessary to move ahead the major national transportation corridor infrastructure project. The landowner's willingness and cooperation with the city up to this point around utility work and other things is much appreciated. So that spirit, I think, is very helpful as the process continues to unfold. There are a number of separate and overlapping but related processes at work here in an instance like this, and it's the view of the committee, which doesn't have final say. Council has final say next week, but it's the view of the committee that it is in the public interest to allow those processes to continue to play out and to continue active and good faith engagement with the parties about the potential for negotiated resolution to multiple processes that are unfolding at the same time. But that in the meantime, we need to be able to proceed with the partial taking and then allow some of those other processes to kick in, and that discussion should continue in that context rather than changing course to the full taking just yet, because there are multiple processes that are unfolding, and some of them need to continue to unfold, beginning with the partial taking of the land immediately to proceed with the infrastructure project. And so the committee, I think, is inclined to accept administration's arguments as outlined in attachment 4 specifically, and we'll need to allow the process to unfold from there. So is there anyone else wishing to speak? Not seeing any, then please vote on the motion as amended with the addition of part 4.
We're just missing Councillor Cartmell's vote and yours, Mr. Mayor, as well.
Yes?
Thank you.
That hasn't come up for me. Oh, here it is. You should have it now.
Thank you. We have 5 votes.
Display the vote. Carried. That takes care of item 6.3. So we'll need to go back in private now, subject to section 16, disclosure harmful to business interests of a third party, and 25, disclosure harmful to economic and other interests of a public body, to deal with 9.1. And but before we do that, Councillor Cartmel had indicated that he no longer needs 9.2. So unless anybody else needs 9.2, not hearing any, do you want to move to bring that forward and we can deal with the recommendation on 9.2?
I will so move. Thank you.
Thank you, Councillor Cartmel. Any objection to bringing 9.2 forward? Not seeing any, then do you want to move the recommendation in 9.2?
I will. I'll move that the proposed settlement is outlined in attachment 1 of the August 23rd, 2021 Office of the City Manager Report OCM 00688 be approved, and that 2, that the August 23rd, 2021 Office of the City Manager Report OCM 00688 remain private pursuant to section 16, disclosure harmful to business interests of a third party, 25, disclosure harmful to economic and other interests of a body, and 27, privileged information of the Freedom of Information and Protection of Privacy Act.
Thank you. Any debate? Not seeing any. Please vote to adopt the recommendation in 9.2.
And we have 5 votes, Mr. Mayor.
Display the vote. Carried. Now I'll take that motion to go on private, subject to the aforementioned section 16 and 25 to deal with 9.1.
So moved.
Thank you, Councillor Cartmel. Please vote to go on private to deal with 9.1.
We have 5 votes.
Display the vote. Carried. Okay, we'll take another couple of minutes to get tidied away here. or 2 months ago. Yeah. How much have we saved on grass cutting this year? Well, usually whatever we save on grass cutting, we give back in tree watering. There's a bit of a inverse relationship there historically.
Mr. Corbold, in future, when you're hiring city clerks, you may have to put them through a fitness test. This one passes. Yeah.
The doors are open and our live stream is back on.
Rock and roll. Okay. Councillor McKean, you want to move the recommendation in 9.1?
I am happy to move that recommendation.
And that it be kept in private, subject to section 16 and 25, as discussed. Okay, so that's before us. Any debate?
Mr. Mayor, in introducing this, I have to be extremely careful to protect the interests of the parties involved. So I'm going to try to do this. This involves what I think is a really critical city partner and with a long history in this community. So I'm really thrilled that they're involved, and I'm really thrilled that this will result in an uplift to a critical part of the city. And that's all I think I can really say, but this is really good news. And I don't know when the news will go public, but I just want to thank administration for their fantastic work on this and recognizing, and administration recognizing, I think, that history and performance by this critical city partner. I'll stop there. Thank you very much.
Please vote.
And apologies, Councillor Hamilton, we can see you're in the right place, but your vote hasn't come through yet.
I'm a yes, thank you.
Thank you. We have 5 votes, Mr. Mayor.
Display the vote. Carried. Are there any notices of motion? Seeing none, then the work of this executive committee is done. I want to thank Councillor McKean for serving as vice chair for the last, 16 months or so, and Councillors Cartmell, Hamilton, and Walters for their thoughtful engagement on a lot of complex issues that have come through this committee over the last year and a half. And even though I guess a good chunk of the time the committee wasn't active because of COVID and we were doing things differently, but I found this committee to be a thoughtful and strategic resource to support the work of council and some of my own leadership and thinking and strategy around particularly intergovernmental issues and some of the housing policy issues that we've dealt with. And so I just want to express my gratitude to each member of committee for their engagement in some of the tough work that we've undertaken. So thank you to each of you.
And thank you, Mr. Mayor, for your leadership on this committee. I say that as vice chair, who didn't really have to do a heck of a lot because of you, so thank you.
Well, I'm obliged to chair executive committee, so it really was nothing. But again, it was team effort, so thank you. Seeing no further comments, thank you all, and We are adjourned.